Thank you, chaps, very much. Well, I let you catch your breath and take your seats. As I was just saying, I was here this time last year, and we had exactly this chat, and we knew it was going to be a big year. Now, 12 months down the line, Anna, what are your reflections on the last year?
Well, I'm going to say something that I feel like I've said every year for the last few years, which is just lots and lots of change. And there's lots of change both in the market and also consequentially at SRA, because we need to respond to that. And I want to point, just picking up the market change, pick up one thing which has become very much more significant during the course of this year, which is the whole area of the market that deals with high volume consumer complaints. That's something that has increased in nature and scale and importance, therefore, for us during the course of the year. So we've been proactively looking at what's happening in that marketplace. And as things stand, we've got more than 70 investigations sort of in hand. We've closed down 5 firms. We've issued a number of warning notices, and consumer information has been provided as well. But we're really concerned that while we did that, I mean, the investigation should be finished by the end of this year, but while we did that, there were still issues developing in the market. And so we took an unprecedented step this year of writing to 700 firms and asking them to make a mandatory declaration about compliance in this area to try to raise people's sort of attention of the importance of getting this right. So that's a very different way for us to behave, and all begs the question of how we need to regulate in the face of these very significant changes or developments in the market. So another example that we talked about last year was in relation to the safeguarding of client money. And since we met here, we've been out to consult and had a lot of discussion with everyone in the sector about what the right course of action is, and we will shortly be proposing some medium-term measures in relation to that, so another set of changes. And finally, the sort of third implication for us is this question of how do we regulate, how do we build a better basis on which to identify risk, so that we can address issues for consumers, ideally before they happen, but at least minimize the detriment, if there is detriment, that will follow. And that's what we've called our data and risk programs, getting there first and fast, because we have the data that we need in order to understand where the risks are. So those are kind of 3 big changes, one in the market and 2 are responses to it.
Paul, we're obviously going to talk about SSB in some detail in a moment, but before we do that, any other reflections on the last year from your desk?
Mm-hmm. Well, Anna's obviously picked up on some of the big ticket items. There are 1 or 2 other issues. So if you look internally at the amount of concerns or complaints that we're receiving about solicitors, over the past decade or so, we've routinely received between 10 and 12,000, what you might call complaints about solicitors, usually from clients, often from other solicitors. And actually this year we're looking at something closer to 15 or 16,000. So that's a very, very significant increase. And we're looking into why that's the case, whether it's just an increase in consumerism or people much more willing to complain, or whether it's the fact that the service that they're getting is getting worse. There's no evidence of that, but we just don't know what that is. So from an internal perspective, that's causing a bit of strain on the system. There's no doubt about that. And then, of course, we have the evolution of SQE. We're now about 4 years in. There's about 30,000 people gone through about 19 different assessments. And there's an ongoing discussion as to how it should iterate, whether it's too easy or whether it's too hard, or whether or not it's just right. And I think overall there's about a 66% pass rate, which from my point of view is definitely in the just right zone. But there are alternative views there. And I don't know if anyone managed to watch the documentary on Channel 4 last night, Dispatches, where they talked about whether or not AI is going to, steal jobs. And they did 3 or 4 different scenarios from different types of industry. But one of them was the solicitors' profession, and they talked about Garfield, the new AI product that we regulated the business during the year. And this is a product that looks at helping people with small claims and how they go about doing that. And it's worthwhile having a look. I'm sure you can watch it back in whatever app it is. But it really gives a sort of real-time understanding of how a user would interact with the software. At the end of the day, the software charged £100, the solicitor charged well over £1,000, so it's a tenth of the price. Now, whether or not that is the full Monty yet or not is not the issue. The issue is what's it going to be like in 5 years' time? And what does that mean for the profession? And I think that's probably one of the widest sweeping questions we have to ask ourselves today is what does the solicitor's profession look like in 5 or 10 years' time with the implementation of various AI products across the piece?
Okay, let's move on to SSB. I'm sure most people in the room will be fully aware that there was a report, a critical report last week by the LSB into the SRA's handling of the SSB case. It was critical in how you dealt with the complaints ahead of the firm collapsing 2 years ago. Anna, what was your response? What is your response to those criticisms?
Well, I mean, in short order, I think it's right to say that we could and should have done better. So we absolutely accept the findings of the report and the recommendations that have been made. But I think the most important thing I want to say is to apologise on behalf of the SRA, particularly to those consumers who were affected. And I think, you know, we are sorry that we did that more quickly. That's what we should have done, and that's what we need to do in the future. And that we're particularly sorry that that our handling has had a consequence for the harm and suffering which many consumers have experienced. So as I say, we accept the recommendations of the LSB report. Fortunately, we haven't stood still in the 18 months since this was the report was first commissioned, and we did our own serious event review immediately and have taken a significant number of actions already, and many are in process, which are consistent with the things that we will be required to do to address the recommendations, but not the full set. There's more to do. So it's an ongoing program of work. And the biggest issue that falls out of the report is this question of our ability to join the dots of the various points of data that we have, making more than the sum of the parts and identifying the issue in a particular firm or indeed in a particular sector of the market so we can take action. And that's sort of a work in progress. We're getting much better at that, but we're not finished. So all of that represents a very significant shift in the way that we need to operate. But as I say, going back to the beginning, we accept the recommendations of the report and we're sorry for the consequences.
Paul, if you had these complaints and they weren't acted upon, and you've got an increase that you've just mentioned, a significant increase in complaints, that doesn't sound like a very reassuring picture.
We've got an increase in complaints. We're obviously increasing resource accordingly. We have an accommodating board that has given us the green light to recruit lots and lots of new staff. That will have implications. It has had implications for the amount of money we need to collect from the profession. So that's not such an issue. In terms of SSB itself, I think it's been well reported in the press that we've already placed interim conditions on a number of people, and we expect to make decisions and announcements quite soon in terms of where we take it from there. So the individuals in question, if the evidence is there that they've not done what they should have done, then we will deal with them through a normal process.
But so far, nobody's lost a job.
Well, I mean, there's been very significant change in personnel at the SRA since SSB became evident. And as a result, We've had almost wholesale change at the senior exec level, executive directors, and I think everyone in the room will be aware of the fact that this is Paul's last compliance conference, and he hands over the baton to a new chief executive, Sarah Rapson, in no less than 8 days' time. So we have had huge change at the top, actually, and are about to deal with even more. The board are very clearly of the view that we need to retain a bit of continuity as this process happens. So we need continuity of leadership to ensure that the lessons that need to be learnt are learnt and that changes are properly implemented. And we need to support an incoming CEO who will have to learn the ropes, of course. So we're very focused on doing that, and continuity is important for it. But alongside that, we will continue to refresh and renew the skills that we have available, particularly around the board table. So that's the bit that I might be more responsible for. And we have this year recruited 2 new board members, specifically with an eye on this new agenda and what we need around the board table to help us with that. We expect to make 2 new appointments next year to the board, so we'll be looking at further skills strengthening. And my own role comes up at the end of my term for recruitment. So this is a constant process of change. And in order to be functional, an organisation needs a bit of continuity as well. And that's why the board are clear that we think that's something we need to hang on to just for now.
I mean, I only ask that because obviously I've read people saying heads should roll and maybe this is a resignation matter for either or both of you, but you don't think that that's the case?
We don't.
Yeah, okay. Obviously, the SSB case was linked to wider issues that others have highlighted, the growing concerns we've already touched on, high-volume consumer claims are handled and the risk that poses to consumers. What's your area of concern, or are you concerned about that, and what's happening about that?
So we have a huge programme of work in this respect. We've had to get people to down tools in other parts of the organisation to focus on it because it's become evident that the issues in the high-volume consumer claims market are, if you like, systemic. They're specific, probably, to that part of the market, but they are significant. So we followed the breadcrumbs from SSB, and we found that other firms were involved directly in relation to SSB, but we have subsequently then done a thematic review and identified that the issues are fairly widespread. And as I said earlier, we've got a very large number of open investigations, and we've had some closures, plus, of course, the mandatory declaration. But these, so we are seeking to do everything that we can. I think our conclusion, going back to the idea of change and how we need to regulate to address new issues in the market, we have just published a discussion document which seeks to have a conversation with people about, well, in a situation such as this, where there are very particular issues in a subsector of the market, should we regulate differently? Should we be requiring more information of the profession? Should we be a bit more intrusive in the way that we do things? So those are important questions, but they would require more change in the way that we regulate. And we've just, as I say, published a discussion document which we want to talk to people about. So it raises some very big questions. And I think this is, if you stop and pause for a second and think about the Act in 2007, what it did was it introduced all sorts of opportunities for the market, for firms to develop in different ways. And this, in a way, is one aspect of the crystallization of that. This is the sort of change which could be great because it offers more consumers access to justice by supporting them in with these sorts of issues, but can also be problematic if it's not done properly. And just a final thought, not all the issues rest in our hands. So one of the one of the potential drivers of some of the poor behaviour in the high-volume consumer claims market is third-party litigation funding, which, of course, is outside of our control. So in this work, everything that we're doing is there's a bit of collaborating with others in order to deliver a better marketplace for consumers.
Paul, on the discussion paper that Anna mentioned, is there anything that you can tell, if people in this audience who might think, oh, this is something I'm going to have to prepare for, what's in this discussion paper?
Yeah, I can tell you to please read it and please do respond to it. So we cover 4 or 5 really important things. Anna's already touched on a number of them. The first is really about transparency for consumers. What does no one, no fee mean? Often it's interpreted as no one, no cost. And of course there is a cost because you actually get it taken out of your winnings if you want. If you don't win, then there's no fee from the solicitors that are acting for you. But there might be a consequence and cost on the other side. And because of that, there's an insurance product that's developed called after-event insurance. And what happened in SSB is that probably for the first time in whole-scale terms that we're aware of, that insurance didn't pay out, which left people vulnerable and facing bills from the other side. So we'll be looking at that too. We're looking at third-party litigation and the part that that plays. We're looking at an important issue that Anna's raised in relation to our risk work, which is risk and data requires data. It requires intelligence. And actually, one of the weaknesses that you might argue about the SRA is we don't know enough about the practices of law firms. We don't know how much work they do in particular areas. We don't often know certain metrics about the way in which the business works. And in order to be better at identifying risks and patterns, in order to do something proactive, you need more data. And as Anna said, that means that particularly where we identify high-risk areas, such as high-volume consumer claims or built litigation, whatever you want to call it, then perhaps we will be asking better questions and demanding more information of those firms. So we're covering all of that in the discussion paper. I think the date is due to close on the 14th of November, so you have a few weeks. I do recommend that you have a read at it.
Let's move on to consumer protection review. This time last year, we were talking a lot about the arrangements for the protection of clients and their money, wherever that money sits. Paul, can you remind us what's happened on that front?
So we consulted last year, I think it was the end of the summer, on what we called a consumer protection review. And that consumer protection review covered 3 things. The first and the big ticket item was whether or not solicitors should still be mandated to hold client money. An awful lot of the disciplinary work that we deal with in our day-to-day work comes from what you might call misappropriation, mishandling, or downright stealing of client funds. And actually, solicitors are one of the few professions that actually do hold the money of others in that way. So we consulted on that. We also consulted on whether or not you should be able to derive any interest from money which belongs to clients rather than solicitors. The second thing we consulted on is what I would call checks and balances coming out of the Act. Well, actually, it was before the Axiom review, but we had guessed some of the issues that were coming out of Axiom and whether or not we needed to tighten up the regulatory arrangements. And the third thing was to look at the compensation fund. And what we heard coming out of that was everybody likes the protections that the compensation fund provides, although it does, as you all well know, come at a cost. There were very, very mixed and somewhat negative views from the profession about withdrawing the ability to hold client money. And actually, what we're doing now, and what we've been doing since then, is developing proposals coming out of that, which we're about to consult on. And so we're about to consult on issues like changing the arrangements for accountants' reports. An independent accounts report of a client account is required every year, but whether it's sent to the SRA, whether or not the SRA knows that you've actually done it, really depends on trust. And we need to look at whether or not that is appropriate given what actually happened in Axiom Inc. The same thing that happened in Axiom Inc. is that one individual had a huge amount of power and knowledge about the firm and about the client account, etc., etc. And we're having to consider very carefully whether or not we mandate splitting up those roles between the compliance officer for legal and the compliance officer for finance, and looking at how you would do that and looking at the size of the firm and trying to make it proportionate. And in all honesty, the real issue here comes back to regulatory theory about what is proportionate, how much intervention by the regulator is required in order to provide sufficient consumer protection. And the overall argument is that in the light of the events of Axiomans and indeed SSB, whilst there's arguments about what the regulator did, there is most definitely arguments about the regulatory model becoming far more intrusive, far more proportionate, people might argue, in relation to the risk that consumers face. And we will begin out to consult on that in the next 2 or 3 weeks that we expect. And of course, one of the issues already touched on is this idea of data. In order to develop a risk-based approach to understanding patterns from data, which is most definitely one of the failings coming out of SSB, there's no doubt about it, then actually we need more data. And that means thinking about what sectors we need more data from. We've already mentioned high volume claims. Conveyancing might be another. Immigration might be another, where actually the consequences for clients of losing lots of money or being deported and something horrible happening elsewhere are huge. And therefore, actually, there are certain areas, I think, in the future, the SRA will be asking for far, far more information from law firms and paying far, far more attention to where the risk is great.
And is there a timescale on any of that?
Just that we're consulting on those issues probably in November. And in all honesty, we're having, as people know, we receive statute directions from the LSB in relation to Axiom, so we're having to focus all our attention on delivering those directions, which we're well on track to do. But the key issue for me, as I depart the organisation, is this whole idea of holding client money. If solicitors didn't hold client money, the cost of regulation would drop like a stone. There's absolutely no doubt about it. And the board has agreed that although it will focus in the short term on delivering the Axiom directions, it will be returning to whether or not solicitors really should be holding client money in this day and age of electronic banking. And most certainly, if they do in some shape or form, whether or not they should be collecting interest from clients' accounts is still very much on the agenda.
Anna, do you want to come in on that?
No, I mean, Paul said it. The board is. So I've read people say this has been kicked into the long grass. It's not. It's simply that the organisation, for reasons we've just discussed, both the Axiom directions and also SSB, has got its plate very full with urgent things it needs to do first. So that's what we're focused on doing. But the bigger conversation is something the board would like to see us take forward or sort of open up again, and we look forward to having that conversation with our new chief exec when she arrives.
Let's move on to SQE. It's been 4 years or more than maybe since it was introduced. The number, I think you mentioned, the number of prospective solicitors has rapidly grown, but how's it, any teething issues, how's it working out, Paul?
So SQE was probably one of the first discussions Anna and I ever had about 7 years ago. And actually, if we knew then what we know now, I think we'd be very, very pleased. The fact is that the evolution of SQE, the way in which we introduced it, we left the legal practice course still open, and there's the point at which they cross over, and we've just reached that point. So there are more people sitting SQE than there were qualifying through the old arrangement, as it were. 30,000 people, 19 assessments. Actually, we think it's going really well. The quality of the assessment is really high. There were two objectives from SQE. One was ensuring the quality of solicitors and the knowledge base as they join the profession. We felt that the previous system was broken in that the standard deviation between providers was just too wide. So now we have one assessment provider, and actually we're really happy with the way that it's going and the quality of the assessment that is actually done. It's very similar to other high-stakes professions like medicine, as it were, and it's a very tried and tested method. The second objective was to try and increase social mobility in the profession. We think that's going really well. The number one cohort that does really well on SQE is apprentices rather than graduates. And actually, I think there's something like 500 apprentices already qualified for this route. So we're really pleased that that's happening, and we'll start to see a degree of social mobility in the profession. And actually, when we speak to law firms who employ apprentices, they're really, really happy with it. So we think it's going really well. There is some criticism, you're quite right, Daisy, in relation to, well, is it too hard? So the last sitting, I think, of SQE1, 41% was the pass rate. But as I said, if you take it across the board, in all the assessments, there's a 66% pass rate. And I think there will always be this discussion about, is this too hard? But let's be honest here, being a solicitor is an important part to play in society. And we think it's important that we have a robust assessment of those qualifying solicitors. So actually, from a personal perspective, I think it's going really well, but the debate continues.
Yeah. Anna?
Well, so two things really. One is just that when we set out to establish SQE, we also set out a programme of to review how it was going, and we have just completed that 3-year review, or the independent reviewer has just completed that exercise, a review of perceptions, and I think what that is showing is, again, progress. So a headline from the employer perspective is that they have growing confidence in qualifying work experience, and they're positive about SQE overall. From candidates, it's a bit more mixed, and there are some questions about actually relating to the nature of the exam and the difficulty of the exam, and so we think there's a bit of work for us to do to explain why it's designed the way it is, and what benefits that bring. But overall, again, reinforcing, and we're just commissioning the 5-year review, so we'll carry on doing that and in due course make any tweaks to the programme that we need to. But I think another really important aspect of SQE and a measure of success is the way that it's seen internationally. So as we all know, English and Welsh law makes a huge contribution to UK GDP and sort of economic growth, and SQE is a really important part of that because it's the entry level. It's been very well received internationally. We've had thousands of people sitting SQE so that they can say they're qualified in English and Welsh law as well, and as their current jurisdiction. And that seems to be a very important part of the story too.
And Paul, on AI, you mentioned AI already. Just it occurs to me that within the SQE system, presumably AI is already or is going to play a huge part of that.
Yeah, when we developed the assessment, we spoke to quite a number of law firms about what should be in the assessment. Actually, quite a lot of law firms felt that things like project management should be in the assessment, or IT skills generally, or AI skills, etc. We decided to stick with pure law, and that was the decision that we took about 8 years ago. But as Anna says, we're reviewing how the assessment is going, and I can fully see that it will evolve in things like how to use AI, how to supervise AI, how to recognize AI hallucinating, that type of thing, are skills that some of the larger firms are already insisting on having their trainees and their associates actually deliver. And I can see that in the future it might evolve in that direction. Yeah.
Thank you for sending questions in. I can see we've got some. I'll turn to them now. We've had a number of questions on the implications of the Mazur case. What's the SRA's position, and will you be providing more guidance on that?
So Mazur is a case that I'm sure you've read about in the legal press. It's a case on whether or not an individual is conducting litigation, and what does conducting litigation mean, as opposed to assisting in the conducting of litigation.
And this depends on seniority?
Well, it depends on whether or not you're authorised. Yeah. And for the most part, as far as this is concerned, we're talking about solicitors. Solicitors are authorised to conduct litigation. Non-admitted staff, such as paralegals, can be authorised, but they need further training. For the most part, they're not authorised. So the real issue is whether or not the skill mix of litigation firms has been so diluted that actually there are people who are not authorised to conduct litigation that are actually conducting litigation. That's the issue that came before the court. And the first thing to say is that our view is that this doesn't change the law whatsoever, that actually conducting litigation is an obvious thing, but the fact is that whether or not you're conducting litigation or not conducting litigation depends on a variety of factors. The nature of the work, the seniority of the person, the non-admitted person in terms of what they're doing, the level of directions they're given, the level of supervision it's giving. So we understand why it's arisen, but we don't think the laws change. And yes, we will be issuing further guidance. The Law Society put a practice note the other day, and we will be doing something shortly. We're in discussions with the Legal Services Board, however, because the LSB are very keen. It's not just a solicitor issue, it also covers SIAC's members and others, and therefore they're keen that there's coordination around about that. Hence the reason why we haven't done it so far.
Very good. A couple of questions, I think, picking up on your very heavy hint, Paul, that you're going to be demanding more and more data in order to spot patterns and so on. And of course, people are concerned about how onerous that's going to be on them and their individual companies. There's one here saying, if the SRA is being more proactive, will it be proportionate with the burdens on time-poor small firms?
Yeah, so, I mean, to be honest, that's a really good question. And the real issue is whether or not the firm's involved in work that poses a higher risk. So if you're involved in conveyancing, then that, I'm afraid, poses quite a high risk because you have quite a lot of money in your client account and lots of transactions going through it. If you're involved in high-volume consumer claims, consumer litigation, Anna's already articulated that we believe that's a really high-risk area, and therefore we will be developing arrangements to make sure we have the data to drive our proactive work. The whole issue here is we need to be able to identify trends from the data. We need to do something proactive, which is usually inspections, to make sure that actually we deal with those risks before they actually happen. So we are conscious that it will put more burden on law firms, but it's the whole backcloth of what's been happening in the past few years is that the risks are looking much higher than anticipated. The regulatory response will need to be improved and actually be much more penetrative as a consequence, I'm afraid.
Can I just add one thing? So the other side of what Paul is saying is that he identified some areas where we would want to ask particularly for more information because of the high risk. But the sort of counterpoint to that is we are committed to not asking for more information where we don't think there is significant risk. So this is, we could decide to ask everyone for more information, which would feel like a fishing expedition, and it would definitely be disproportionate in our view. Instead, what we're trying to do is identify where we think we need it. And that might change over time, to be honest, because we might not have thought that it was necessary in relation to high-volume consumer claims a few years ago, but it is now. So it will change, but we are absolutely focused on trying to make it proportionate.
There's a question here about SQE. Isn't it just a money-making exercise?
It's not a money-making exercise for the SRA, that's for sure. But it is a costly exercise, and people qualifying to be a solicitor have to pay a hefty fee in order to go through the assessment, and most of them will pay fees for some sort of educational preparation. It is still, for the most part, less expensive than its predecessor, but it costs a lot of money. And I think the much more pertinent question is whether or not everybody who pays that money and finds that they can't enter the profession, is that an acceptable position? Because actually lots of people have aspirations to become a solicitor. They basically spend a lot of money educating themselves, and then there's insufficient training opportunities for them at the end of that. And to go back to my rant about artificial intelligence, in my view, that's only going to make that worse.
Actually, I've just got an AI question here that's just come in. Does more need to be done to protect the quality of legal services and consumers from AI eroding them? How are you as a regulator able to do that?
So again, good question. It strikes me, and I'm not an AI expert, but it does strike me that there's an adoption curve, isn't it, really? And I talked about we've regulated a law firm that is using AI as a sole product for pre-litigation and small claims. Actually, you should watch the programme. It's really insightful in terms of what might happen next. But the outcome of the programme is that the AI was okay, but it needs solicitor supervision. And it's a bit like driverless cars. I seen the other day in the news that actually driverless taxis are kicking off in London next year for the first time. But they're going to have a driver sitting there not driving in case something goes wrong. And that's all about instilling confidence. As people get more confidence in AI products, I think that adoption curve will get steeper. And during that adoption curve, we need to guard against what they call hallucinations of the AI getting it wrong, of the large language model actually coming out with the wrong answer. So for me, it's not about the next 3 to 5 years. You'll hear people who are really into this saying it's all going to happen yesterday. But the direction of travel is clear. All we're arguing about is how long it's going to take to get there. And actually, during that curve, we will be conscious of making sure that there is solicitor supervision of those products, like we do with the Garfield product that was on TV last night. But the writing is on the wall, and I think your question about how we make sure that the profession has the skills in order to do that is a really good one.
And a question here, has the SRA moved too far away from the bread and butter investigations into accounts rules and protecting client money?
That is an oxymoron, if you don't mind me saying. Accounts rules and protecting client money has always been the bread and butter of the Law Society and now the SRA. Always occupied a disproportionately high cohort of our disciplinary work, and it still does. Now, there are many other things, and maybe that's the focus of the question that we look at, such as non-disclosure agreements, slaps, bullying, and workplace sexual harassment. But actually, the level of misappropriation of client funds has not gone down. And actually, that's one of our key consumer protection goals.
Are there still plans for the SRA to take over regulating Silex individuals?
So we're in the hands of Silex
And the LSB.
and the LSB in that respect. We've always said that if we're asked to take on regulation of Silex practitioners, we will. But as everyone can see, it's gone into that long grass, that proverbial long grass, and nothing has happened for quite a while. And we wait to be for confirmation. Is the honest truth.
This questioner says, with reference to the mandatory declaration exercise for firms working in high-volume claims, how does a self-declaration provide reassurance?
Go on.
Well, that's a really good point,
Yeah.
if you don't mind me saying. It provides a degree of assurance and, to scratch
Sort of better than nothing.
Well, scratch my long grey beard, professional regulation has always been based on trust. It's been based on the fact, whether you're a doctor or a solicitor or an architect or whatever, based on the fact that A, you do the right thing and we trust you to be competent to do the right thing. So telling lies on a self-declaration is definitely not the right thing. And it means that if we find out that you're telling lies, then you're in hotter water than you otherwise might be. So it provides a degree. It doesn't provide an absolute assurance. And that goes back to your proportionality question. And therefore, well, maybe we ought to, do a twice-a-year inspection of every law firm in the land and grow to be 20 times the size of the organisation we are. We think that's disproportionate. So we're on a journey, as Anna says, and we are looking at how we can get the information we need as least intrusive as possible. But the fact is that will get more intrusive if we still see consumer harm in the marketplace continuing.
Quick question. I've probably got enough time for one or two more, but this one says, this is a big one, does the SRA feel it's giving value for money to the profession?
Well, I can tell you that we ask ourselves that question a lot at board, particularly when we come to making budgets and going out to the profession with the consultation on fees. And one of the discussions that we have every time at the board and that we ask the executive for a clear view on is where we can make efficiencies. And we'll set targets for that and have programs for it. And that's year after year. So we are absolutely focused on trying to take out inefficiency. But the reality is that the scale of what we're being asked to do has grown and is growing, and the expectations of us as a regulator have grown and continue to grow, and one can't do that with less and less. So it's a balance between delivering what is required of us and making sure that we don't carry fat in the system, and we are very focused on that.
Well, in the last minute of this session, Paul, the clock's ticking in more ways than one, because as Anna's already mentioned, you're coming into your last week or so at the job after 12 years at the SRA. As Jerry Springer might have said, any final thoughts?
Well, just to segue from Anna's comment, I'm really pleased that up until about last year we kept the actual fee for regulation more or less flat throughout the last 10 years. And it has only been in the last 18 months or so that we've seen it actually sharply go up. But I think the theme has changed. Actually, things have changed radically in the last 12 years that I've been here. I've already talked about the nature of the case mix that we look at. It's not just misappropriating client money. There's a whole plethora of things, and I've talked about many of them. Perhaps SLAPS is another one that's actually just come around the corner fairly recently. We reviewed the handbook in terms of a principle-based approach. That was a long time ago now. We changed the education arrangements both for continuing competence and for qualifying, and they need to be kept completely under review. I think we've done really well on AML over the last few years, although there is quite a big announcement later today about AML. So yeah, I think probably SQE is the lasting legacy, because actually, assuming it doesn't change radically in the next 10 years, and the previous arrangement lasted about 30, you'll see hundreds of thousands of solicitors qualifying through the SQE route. And that's probably the number one thing I'd identify as a lasting imprint of my time here.